story highlights a judge ruled that the End-of-Life Option Act was improperly enacted and refused to vacate that decision. A hearing on another motion to reverse the decision will be held June 29. Confusion and fear for an estimated 200 patients who had started the process. Advocate says dozens of terminally ill patients in California who counted on using the state's medical aid in dying law may be in limbo for a month after a court ruling that suspended the 2016 measure. A judge who ruled in May that the law was improperly enacted refused to vacate that decision at the request of advocates last week. Riverside County Superior Court Judge Daniel Otolia set a hearing for June 29, however, to consider a separate motion by State Attorney General Xavier Becerra to reverse the decision. Opponents shared what they hope will be the end of a law they fought from the day it was passed. Compassion and Choices, an advocacy group that promotes aid in dying, filed a notice of appeal late Friday and asked Becerra to uphold the group's legal opinion that their appeal would trigger a stay of Otolia's judgment. Becerra did not immediately respond to the group or to requests for comment. Such a stay would reinstate the law pending further court action. California judge overturns end-of-life option law for an estimated 200 patients who had already started the process of hastening their deaths. The decision has sparked confusion and fear, said Kat West, Compassion and Choices National Policy Director. As of May 30, doctors had stopped writing prescriptions for the lethal medications and pharmacists had stopped filling them, leaving patients uncertain how to proceed, she said. Physician whose practice focuses on aid in dying said more than a dozen of his patients have been directly affected by the suspension. Lonnie Shavelson, a Berkeley, California DR. These are patients who are in various stages of the process, all the way from a first verbal request to those about to get the medication, he said. Diagnosed last year with terminal pancreatic cancer, who has planned to take the drugs when her suffering becomes too great. They include Debbie Gotze-Crater, 69, a lawyer from Half Moon Bay, California. Aid in dying advocates target next battleground states, knowing she had the choice has helped her tolerate the disease, but the suspension has made her very uncomfortable, she said. Crater said she is considering moving to Washington state, where medical aid in dying remains legal, or flying to Switzerland, where physician-assisted death is allowed. Others may choose grimmer options, she said. This has the feeling to me of the coat hanger abortion, she said. People are going to try to take things into their own hands in bad ways. But opponents of what's sometimes called assisted suicide said the suspension now opens the door to a discussion about how to better care for people at the end of their lives. Halting the law likewise has the benefit of protecting a great many vulnerable people against deadly harm through mistakes, abuse and coercion, risks that go hand in hand with this type of dangerous public policy, Med Valier, executive director of the group Patients' Rights Action Fund, said in a statement. It allowed terminally ill adults to request lethal medications from their doctors through a process that requires verbal and written requests at least 15 days apart. California's End-of-Life Option Act took effect nearly 2 years ago. The practice is also permitted in 6 other states and Washington, D.C. 104-year-old scientist David Goodall ends life listening to Ode to Joy. More than 100 people used California's law in the first 6 months after it was enacted. Hundreds more are estimated to have used it since then, though no official reports have been issued, according to state health officials. Shavelson said he has received more than 600 requests and attended 87 deaths since the law took effect. Several groups, including the Life Legal Defense Foundation and the American Academy of Medical Ethics, challenged the law, saying it failed to protect elderly, infirm and vulnerable patients. In mid-May, Otolia upheld the group's motion that the law was unconstitutional because legislators improperly passed it during a special session limited to healthcare issues. Even the strongest proponents of assisted suicide should be gravely concerned about the lack of safeguards and protection in the law that was found to be unconstitutionally enacted by the legislature. Compassion and Choices challenged that decision May 30 on behalf of 2 terminally ill patients and a treating physician, but Otolia rejected their motion. Stephen Larson, a lawyer for the plaintiffs, said in an email. However, Otolia granted a request from Becerra to consider a separate motion on the same matter June 29. That leaves patients and doctors without clear answers for at least a month, Shavelson said. Follow CNN Health on Facebook and Twitter. See the latest news and share your comments with CNN Health on Facebook and Twitter. Among the questions, if Shavelson accepts a patient's first verbal request now, will it count toward the waiting period? Will patients who use previously obtained medications have their deaths classified as suicides? rather than as a result of their underlying illness as required by the law. Would doctors who provide the lethal drugs be legally liable for actively dying patients? Even a temporary pause in the law could have a profound and permanent effect. Shavelson added, they are sick, home on oxygen, at home on hospice, in pain, wondering how they're going to die. He said, I have to tell them we don't know.